Law Self-Defense Platinum member Dave says, here's an interesting case which may not turn into a case at all. A woman shoots a carjacker with his own gun. She takes it from him. I'd be surprised if she's charged at all under the circumstances, although it's possible she wasn't in direct danger at the time she decided to shoot and was just defending her car after she had been pulled from it. So there's a link here. I didn't bother go looking at the case. I'll just speak to the legal principles here generally. But it's always the same, folks. It's the same 5 elements. So a carjacker points a gun at you, and you manage to seize control of that gun. Are you allowed to shoot that carjacker? Well, are they an imminent, unlawful threat of death or great bodily injury? It's the same legal standard, always. It doesn't change. So if you grab their gun and they start backpedaling away with their hands in the air, can you shoot them? I mean, are they an imminent, unlawful, deadly force threat in that moment? Maybe not. If you grab the gun and they charge you to try to get the gun back, are they then an imminent, unlawful, deadly force threat? I would argue yes. They're in the process of arming themselves with the gun you have in your hands. That's the Kyle Rittenhouse, Rosenbaum scenario, right? Rosenbaum was unarmed, but he was arming himself. He was arming himself with Kyle's rifle, or attempting to. So it depends on the facts of the case. But the legal question is always, were you facing an imminent, unlawful threat of death or serious bodily injury? That's the algorithm. And if the facts meet that, then it looks like a lawful use of deadly force in self-defense. And if they don't, it doesn't. In terms of using the gun just to protect your car, if there's people in the car is sheltering people. You're really defending people. So if there's a passenger in the car, it's really a defense of person scenario, not a defense of property scenario. If the car is empty, and you're literally just protecting the personal property of the car, unless you're in Texas, you can't use deadly force to defend personal property in the absence of a threat to persons. In Texas, you might be able to if you jump through the necessary hoops of their deadly force and defense of property statute, which is Penal Code 9.42. We talked about it quite a bit in yesterday's show about the Taqueria shooting. You can look it up at lawofselfdefense.com/942. Read it. There's a lot of conditions. There's lots of use of the term reasonable in that statute. Reasonableness is not something that's determined by you folks. It's determined by police, prosecutors, judges, juries. And if their determination of reasonable is different than yours, it's their determination that controls your legal fate, not your determination. So I would caution against relying, even if you're in Texas, relying on that deadly force in defense of property statute. Having said that, I've seen it effectively applied. I've seen charges not brought in Texas because of that statute where someone was killed purely over personal property. So it can work. I would not want to put the rest of my life in a cage at risk of a jury, an unpredictable and dangerous jury, deciding that my facts don't meet the conditions of that statute. Because it doesn't matter if they're wrong or irrational or politically motivated. All that matters is the verdict. And they don't have to explain their verdict.